Welcome to the latest episode of A Better Conversation, a podcast put on by A Better Dallas. As always, I'm your host, Chris Clement, joined by the man, the myth, the mustache, Mr. Kyle Mason.
Thank you very much. I'm very excited tonight. We have an expert that is very qualified to educate me and the viewers on law and lawyering and powdered wigs and things of that nature. So it's going to be really fun.
Right, we have a chief with us. We don't have just any kind of judge. We have the chief from the Fifth Court of Appeals, Mr. JJ Koch. Thank you so much for joining us.
Thanks for having me.
And there's been a lot going on in the Trump administration over the last 6 months in the courts. As we talked about a little bit in pre-production, the news media doesn't always do the best job of explaining what's going on. So really what we're hoping to do for you here today is bring, the legal mind that will be able to break all that down to you that you can trust and say, okay, I understand what the press is trying to say when they talk about a temporary restraining order or a writ of cert or things along those lines. Before we dive into all that, if you wouldn't mind introducing yourself to our audience, tell them a little bit about yourself.
Sure. Often enough, my last name gets mispronounced as Koch, and I think I made the brief joke that perhaps I'd be wealthy in someplace else if I was related to the Koch brothers, but it's Koch, so JJ Koch. I came to Dallas in 2002 after going to Duke University, and I have my dorky Duke cup with me, and a host of dorky Duke things that I have all over the place.
Thank you for Cooper Flag.
Yeah. Oh, gosh. Yeah. That's going to be great to watch in the coming years here. But came down to Dallas in 2002 to go to SMU Law. I met my wife there in law school. And, we've built a good life here in the city of Dallas proper, but of course, in Dallas County. I've been long involved with Republican politics, probably while in law school, started knocking doors for guys like, Tony Goolsbee, Dan Branch, folks that either they don't remember or don't want to remember. Bill Keffer. First worked as a DA. So I worked for the district attorney's office, then was private practice attorney representing police for the Dallas Police Association. Started a tech company, before that, worked for a law firm for probably the longest stretch of time, 6 or 7 years. And at that time, around 2010, I actually ran for judge for the first time. So I ran for one of the misdemeanor benches against a former Republican, someone who'd flipped, and in my experience, just didn't like the way that she was running her court. So I was going to make it right. So that was my first foray into politics, and of course into judicial politics. Years later, after both kids were born, Maureen Dickey and I had developed a relationship back from that race in 2010. And at the time, Commissioner Cantrell was stepping down. And kind of the part of the sale or the talk about it was like, hey, I know you're first interested in running for the judiciary, but Commissioner's Court does a lot in criminal justice, whether it's funding the jails and the courts or, just the host of activities they have to take part in order to make criminal justice work in Dallas County. So I said, all right, I'll run for the spot that Cantrell is giving up. That was a messy, contentious primary, which I eventually had won by a whopping 40 votes.
Wow.
Yeah. That was a heck of a deal for the first. Fortunately, it was my first foray into politics, but it was definitely the one that gave my wife the idea that this has got to stop. But so I won that race. Then was redistricted out of the Commissioner's Court for all the right reasons. Fighting Judge Jenkins tooth and nail.
I expect you were my commissioner and then you weren't my commissioner.
Yeah.
I went from 2-1 in Dallas.
Yeah, no, it was. I mean, everyone talks about gerrymandering, and of course, early in my career on the Commissioner's Court, the body was, what's going on in Austin is terrible. You can't go and gerrymander, and then turned about being not fair play or whatever. They decide to go and do that to me. Which, that's their prerogative, right? They have the power of the pen. It is what it is. And I showed them in that the governor decided to give me a shot at my original dream of being a judge. I was appointed to a district bench that was vacated by a Democrat that had been elected to the Fifth Court of Appeals, now Justice Nancy Kennedy. And I ended up following her onto the court. 2 years later, ran for Chief Justice of the Fifth Court of Appeals, and this past November won that spot, and have been working hard at it since.
Our Republican Magnificent Seven.
Yes, yeah, it could have been 8.
Could have been 8.
Could have been 8, but it was very close. I mean, I don't think people realize that saw the results on election night. They saw 40,000. It narrowed significantly. All the folks that helped, grassroots, and that everyone that put in that effort. I mean, every one of those votes mattered because one of us didn't make it. Many of us would not have made it, but for all the things that were poured in on our behalf, and we're all very grateful for it. Because Mike Lee says every day, I walk past him every day, I love this job. This is the best job I've had in my life, and I just smile and say, just keep pushing out opinions because we got work to do. So I'm happy you're happy, and keep doing the work.
Well, you talk about somebody that won't take no for an answer and keeps at it. I mean, I joked with him at one point. I was like, hey, you don't have to run for 6 years, right?
Yeah.
You have to campaign for a little bit. So,
Hey, did you know of Better Conversations on social media? You can find us on Instagram, Facebook, and X. Following us will not only keep you up to date on our latest podcast drops, but will also keep you informed on current events around DFW, including election news, volunteer opportunities, and social events like late cleanups on Saturday mornings or our happy hours throughout the month where you can meet like-minded people in a fun social setting. You can also meet local politicians and activists that are our guest speakers. Follow the links below to connect.
well, you talked about a few different things that I want to kind of break down for our audience a little bit. First, so you're on the County Court of Commissioners, which is called the Commissioners Court.
Right.
And it's run by the county judge,
Right.
which in Dallas, unfortunately, is Clay Jenkins.
Yeah.
And then you also talked about being on the bench and in a district court position.
Yep.
Could you explain a little bit to our audience, the separation, or maybe some of the overlap, but really the separation between your county court of appeals and more on the judicial side?
Yeah. So your commissioner's court is amalgamation kind of vestige of the past, like the Spanish municipio, basically. So it was a just add water, easy government you can drop someplace. So you'd have a county judge, or the head of this executive body would be a judge and also act as a judge. They'd sit as a body of 5 and then act kind of legislatively, but also would have executive authority. So you kind of vested all your power in these 5 people, and it was just kind of an easy, just add water government when you started to have these large swaths of territory. Then this is the Spanish were doing this, and then it was basically copy and pasted into the original Texas Constitution, and then into the later. After the Republic, and once we became a state, same deal. So we held on to this form of government. There's similar types of county bodies. Sometimes it's called freeholders. There's different things, but ours is unique in that there are some places still in Texas where that county judge actually does have judicial functions. In larger counties, they don't anymore, and it's really just kind of executive, lightly legislative. And that's really what your commissioner's court does. So I mean, it sets the budget for all the county things, and all the county things are the courts, right? So you got to pay for all the courts, you got to pay for the jail, you got to pay for the sheriff's office. You have to fund portions of the tax assessor collector, right? So there's county roads, right? So and basically, if there's not a state road and a municipality isn't there, then the county is going to be all the roads that exist in a place. That's a lot of the work that those rural counties do. Basically, is their roads, and they got to do law and justice, and that's about it.
I grew up on a county road.
Yep.
Right. CR 155.
Yep. So that's what your commissioner's court does. They fund the building where the courts are going to be held. They handle funding the court reporters, and they handle the personnel matters, that a lot of things that go into supporting those courts. So there is currently an uncomfortable relationship that exists between some of these courts here in Dallas County and the district courts, because you have 2 practicing lawyers on the commissioner's court, and one that is the spouse of a very well-known practicing lawyer, which causes a lot of people a lot of heartburn. So that's one unfortunate connection between the courts and the county commissioner's court. But beyond that,
Too many plaintiffs' attorneys on the commissioner's court.
yeah.
As a defense counsel, I would say.
Yeah. So yeah, I mean the commissioner's court basically funds the thing, and then it's up to the county judges and district court judges to do their job in their respective verticals. And if you want to talk a little bit about those, the segregation of benches.
Yeah, it's kind of go back again. So, in Texas, we have 254 counties. We largely have 254 different ways that they do things. Dallas County, with its major population, to your point, has a bunch of different courts, a bunch of different criminal courts, civil courts, misdemeanor courts. It's really divided as opposed to, I don't know, we'll say somebody like Cook County, where I grew up. You really have like the district court is the court of general jurisdiction,
Right.
where kind of everything will fall under that. So
Right.
I think most people understand that sort of general jurisdiction, but how is it broken down into Dallas?
Yeah. Yeah. Well, and it helps to kind of go back and forth between little county and big county to kind of understand. So if you're out in Cook County, you have your county judges. Your county judge will handle, your misdemeanor matters in the criminal side and matters under a certain dollar threshold in the civil matters, and of course probate. Then the district judge, in many places, 5 or 6 counties or even more will be under one district judge, and that district judge will handle your felony matters, your larger civil cases, and your family law cases. They're not handled by the county courts, but on the other side of that, the probate matters are not handled by the district courts, just how they decided to split that all up. The divisions become starker in places like Dallas County once you tell the legislature, and the legislature is the one that makes that distinction on what your courts are going to do. Collin County has district courts of general jurisdiction. So you go to a district judge, and they may have their criminal practice that day. They may have some civil matters, and they may have some family law matters. In many of the large counties, they segregate those courts. So a district court becomes purely, by statute, becomes purely family law court, purely a felony court or a criminal court, and then purely a civil court. There's different thinking on whether or not that's good. I mean, to my experience, I do think that specialization is good. You're going to have judges that are focused on an area of law. The timing of practice is going to be the same. I mean, you're dealing with a lot of the same issues. Criminal matters, of course, always take precedent. So if you have pressing criminal matters, you're constantly going to be pushing civil matters to the side and family matters to the side. So I tend to am supportive of once a county gets large enough to start to segregate those courts. But, not my call. If Collin County wants to do it that way, they can do it that way. And actually, many of the decisions that we receive from Collin County, we can look at them and say, I just got a criminal decision. I'm now dealing with a parental termination from the same judge. And there was a civil matter about, 2 months ago, and on all of it is, done well. And I can see that, they're doing the right thing. So, they're fortunate to have judges that are well educated on many facets of the law.
They do, and I will have to say we have a former Collin County judge on the Fifth Court of Appeals now,
Yep.
right? Judge
Miskell. Yep.
Yeah, Judge Miskell.
Yep.
And so coming back to Dallas County, we have 2 courthouses, right? We have our George Allen Civil Courthouse, and we have Crowley, not the city, the building.
Yep.
For all of our criminal type of stuff. But even within those 2 buildings, like you said, we have even more specialized courts.
Yeah. So you walk into the Crowley building, and on the lower floors, you have your misdemeanor courts, they're county courts, right? And then you have your district courts on the higher levels. And then same type of thing. So, broken out a little bit differently in the George Allen building, but you have, county courts there that are civil courts that are hearing smaller matters. You have probate courts that are hearing just guardianship and probate matters that are county courts. And then you have the district courts there as well. Some are family, right? You have some of the family law cases, courts on the east side of the building, kind of the nicer side. And then, the rest of the civil courts there. So they're all kind of lumped in certain places, and you can easily find them.
And so another distinction to make is everything we just talked about, those are all state courts. So in addition to that, in Dallas, we also have a federal court. And the Northern District of Texas, the Dallas Division, is right down the street from George Allen downtown. Would you talk to our audience a little bit about the distinction between what the federal courts are going to decide and what the state courts are going to decide?
Well,
I know that that's an entire semester of law school, and I can feel the tension of asking a judge to overgeneralize like that, but as best as we can,
it matters in federal jurisdiction. So if it is a federal statute, if it is diversity jurisdiction, so if I'm dealing with someone that's from another state, then yeah, I'm going to go to federal court. So broadly, those are the two biggest things: federal statutes and diversity jurisdiction, or why you're going to the federal courts. State statutes, state matters. Two parties that are entirely dealing with issues within the state of Texas are going to go to your state court. Sometimes someone may try to go to federal court in the first instance and get rejected because they don't have jurisdiction. And other times someone will walk into a state court with a federal matter and they'll be removed to federal court. And you know that well, but hopefully now the folks out there do.
I did not know that.
Yeah.
yes.
So,
Well,
I'm learning a lot here. So just calm down.
Well, in my practice, I do a lot of constitutional law. And what a lot of people don't understand is that you have a Texas state constitution and you have the federal constitution. And in the Texas state constitution, you do sort of have your Bill of Rights. It's not quite as succinct. The Texas constitution gets amended a lot.
Yeah.
But you have a lot of the same causes of action to where if you want to be in Texas state court, you can bring, for example, a takings claim under the Texas Constitution, or you can bring it under the federal Constitution, or what some plaintiffs' lawyers try to do is bring them both together in state court and hope that it doesn't get removed.
Yeah. Yeah, no, there's plenty of that, and there's still plenty of times where you have state-based matters where you're going to use your federal rights and your federal Bill of Rights to advocate in state court, and you very well can't stay there. I've got a funny question for you.
All right.
All right, this is one that gets people, so be ready for it. In both the federal Constitution and the state Constitution, right? Does a criminal defendant have a right to an appeal?
Ooh, that is a good question. First of all, I don't practice criminal law, so my ignorance is immaterial to my normal practice. Under the Constitution, I don't think so.
You're right.
Yeah.
And it's funny. There are people that deal exclusively in appellate law that don't know that. So, huge gold star.
Wow.
You got the big one for today. But it's one of those things, and it's just kind of an interesting thing about constitutions and rights that people don't realize. You do have a right by extension to counsel for your first appeal in a federal case and in state court, but much of what we do at the appellate court regarding the criminal appeal has to be it's undergirded by the fact that this is not a constitutional right. The only representation is a right for the criminal defendant, but this first appeal is not a constitutional right.
So if I guess, does it depend on what type of crime you committed, whether you have a right to appeal or not? I mean, if you don't have the right to appeal, why do we see so many appeals?
So you always have, because of statute in Texas and at the federal level.
Statute means we've done it before.
Well, no, statutorily, the legislator said, for any offense that you have, you can appeal this from a Class C misdemeanor, right? From a traffic ticket, right? And then you'll have county courts of appeal that'll handle that first appeal, and it can go to my court, and it can go to the Supreme Court, right? But the legislature is the one that gave you that right to appeal. They could take it away, they could amend it, they can change it at any time, right? Same thing with the federal courts. The federal courts do handle misdemeanors because they got the jurisdiction in D.C. So you can have spitting on the sidewalk stuff that goes to a D.C. municipal type court, a federal court, the Supreme Court, depending on how that rolls. But it started, right? Your first right of appeal was statutory, written by Congress.
Okay, so it's not in the Constitution, or it's not like a bill of one of the bills of rights to.
Like the Constitution gives you a right to a trial.
Gotcha.
Right.
Not a right to appeal the decision of the jury or the judge in that trial.
Okay.
Right. And it's kind of important things to suss out, particularly when we're talking about, how are we different than someone that's more liberal regarding looking at these things. We're different in that, we're interpreting the Constitution as it was given to us. You have a right to a trial, right? You do not have a right to an appeal. Where does it say appeal, right? Well, statutorily you get that right to appeal. And there's, I don't want to be flippant about it, but kind of have your Roe v. Wade example there. Where in this document is this right to abortion? Right,
It's a penumbra, sir.
It's
a
the penumbral rights, and that was a decision made during a wilder time, and we are in a less wild time.
Wow, we're in a less wild time. I feel like everything in history is happening right before my eyes, but I guess not.
Regarding the court, we're in a less wild time
Okay,
regarding the court.
good.
We're going back to what the words on the paper mean,
Interesting.
rather than penumbral rights.
I mean, we talk about wild times, but I mean, it does. In the 60s, we did see a president killed.
We
We
did.
saw the civil rights leader killed, and we saw the president's governor and
Yeah.
potential future president
And
killed.
Yeah.
Weather underground, tons of pipe bomb. I mean, yeah.
Right.
yeah.
Like, we
Good-
did have
good
some wild
point.
times in the past.
Good point. Yeah.
So that's a great breakdown as far as, he did not give me that question ahead of time.
Chris is really soaking this up. He's like, "I just killed him on
really,
this."
like,
You
yeah.
can take a victory lap.
I'm gonna
Take
put
a victory lap.
We're gonna put it on. I just started a new law firm. We're gonna put it on the website and everything. Not stumped by the chief.
He got his degree without AI. But that was,
Well, AI that's a whole different
Yeah.
thing. We can talk about that for a whole podcast as far as what it is in the legal world now. So we talked about the difference between the federal and the state. And we were discussing appeals. I want to first talk about federal appeals and what that process is, because it's a little bit more streamlined, I would
Yeah.
say, than maybe it is in the state side. So you've gone to trial, either in a civil case or criminal case. You want to appeal it in federal court.
Right.
Where does that go?
That goes to your Fifth Circuit Court of Appeals. They sit in Louisiana. They sit in New Orleans, and they sit in panels of three, just like we sit in panels of three. They can go en banc, just like we go en banc, which means the entirety of the court. Once someone doesn't like what that panel of three has done, they can say, "Well, wait a second, I want all of you to hear this," and they can decide whether or not to do that. But yeah, that's your first step before, if you're going to take this thing all the way up to the Supreme Court. Get your final judgment from your district court. Now you're going to the Fifth Circuit. You're going to go before that panel. That if you don't like what the panel said, you ask, "Hey, I want all of you to listen to it." If all of them say, "We're not listening to it," then you go and you take your shot at the Supreme Court.
Well, and we talk about rights under statutes. So with the Court of Appeals, the Fifth Circuit, which is somewhat confusing in Dallas because we have the Fifth Court of
Yeah.
Appeals and we have the Fifth Circuit.
Yeah.
So federally, the Fifth Circuit, makes up Mississippi, Louisiana, Texas.
Yeah.
If you want to appeal from the federal court, a federal trial court, I will just say have a statutory right,
Yep.
not a constitutional right, but a statutory
Yep.
right to appeal that to the Fifth Circuit.
Yep.
And the Fifth Circuit, if it has jurisdiction, has to take that case.
Yeah.
How is that different if you want to appeal the Fifth Circuit if you want to go up to the U.S. Supreme Court?
Well, like our state Supreme Court, the United States Supreme Court selects its cases. They don't have to take anything. They are looking for opportunities to get things right. They're looking for, circuit splits. The biggest circuit splits, of course, exist between our Fifth Circuit and the Ninth Circuit, California.
Right.
And there's tons of room for opportunity there for them to say, okay, we've decided things two entirely different ways. We need to go and get this right for everyone, so we can all be making reasonable decisions based on expectations. They only have so much bandwidth, even though there's 9 of them, and they have some of the most brilliant minds helping them in the background. They can't in a term. They can only take so many cases. So there may be terrible things that have happened, and they just can't fix it because they are more focused on making law and preserving the status of the most important big issues. They just can't take everything.
Well, it kind of add a little bit to they can't take everything, and I'll just use Texas as an example, right? So in Dallas, we have a federal courthouse, which has a number, I don't know what the exact number is, a number of federal courtrooms, a bunch of different district court judges, magistrate judges, the building's full of federal courtrooms. But that's just the Dallas division of the Northern District.
Yeah.
You also go up to Wichita Falls.
Yeah.
You go to other parts of the state, for other parts of the Northern District. And then Texas has 4 districts.
Yep.
So you've got north, south, east, and west. If you're in east, you might be in Plano. You might be in all the way out in Marshall.
Yep.
You know, you pretty wide swath all the way up to Sherman. But there's a number of these federal courtrooms that all can be appealed at.
Right.
And so when you get to the Supreme Court level, 50 states having all of those different divisions, all those different courts, all getting up to them, it's a massive amount of cases that they see.
Yeah.
So this, you know, a very small percentage. If you want to, you file a petition for cert or petition for review in the Texas Supreme Court, and the Supreme Court gets to decide which issues, and I hate to put it this way, are important enough for them to be able to devote time and resources to.
Yeah.
So another wrinkle that we have in Texas. So in Texas, we also have the district court level up to the Court of Appeals, and what we have 14 in the 15th court that we have now.
Yeah, we had 14. We have
Right.
15. The 15th court has statewide jurisdiction, but they only deal with appeals from the business courts and then appeals from any of the other 14 courts that has the state of Texas as a party.
And that was recently created. So geographically, you have the 14 districts that are spread out amongst the state, except for Houston, which has 2.
Yeah.
But they're spread out amongst the state. They handle, you know, appeals from their courts in their geographic area.
Yep.
So you're, you know, the head man there at the 5th Court of Appeals here in Dallas. Which counties do you receive appeals from?
So Dallas County, Collin County, Grayson County, Hunt County, Rockwall, and Kaufman. So it's the smallest geographic region with, just as it kind of works out, the most population.
One of the things that is you're talking about all of those different kind of counties, and I obviously you can't talk about specific cases, but it seems to me that there would be a pretty wide variety of matters that you're getting from those 6 represented counties.
I mean, I think the more not more interesting. Clearly, most of what we're seeing is from Dallas and Collin, right? Because the parties either have the time, money, wherewithal, whatever, to get it up to appeal. I could foresee, in Grayson and Hunt County, there's plenty of times where someone may want to take a shot at the Court of Appeals, but they don't have that ability. We're seeing more and more cases appealed from Rockwall and Kaufman as they grow. It's just more a matter of population.
Got it.
Just to put a number, the Supreme Court receives approximately 7,000 to 8,000 petitions every year, and they review less than 100 cases.
Yep.
So you got to be pretty important to get up there.
Oh yeah.
But even when you say that, so just 100 cases, when you consider the level of briefing and the level of complexity a lot of these issues, especially when you have a lot of issues the Supreme Court is designed to hear, like, oh, well, this is a question of first impression.
Yep.
So in legal parlance, when we talk about a question of first impression, is basically, well, no one's ruled on this before.
Yeah.
Maybe it's a new statute, maybe it's a new way of arguing a constitutional right, but no court has addressed this issue before. So
sometimes it can be small things too.
Right.
I had a case of first impression. It was just something that kind of, a statute that's existed for a long time, and just kind of fell through the cracks. And finally, we had to say, okay, this is the law on it. And being an intermediate court of appeals, the Court of Criminal Appeals can tell me that I'm wrong, but someone had a rule on it, and I was the one. So,
well, I'm glad you brought that court up, because at the highest level of appeal, it splits in Texas.
Yeah.
So we've got, not only do you have the Texas Supreme Court, which that's going to be your civil issues largely,
right,
and then you'll have your Court of Criminal Appeals, which is the Texas Supreme Court on the criminal side.
Yeah.
Do you happen to know why we have that split?
That was just a legislative choice long ago, and it, decided to put that in the Constitution. We're one of 2 states that do that. It does have some sense in that it allows for that greater specialization, and because of the dire nature of the death penalty cases directly appeal to the Court of Criminal Appeals. And, there's a part of me that, if you're going to be taking a human life, you're in the governmental business of taking a human life, you better be,
Right.
really well situated to do that in such a way that you've done it justly.
Yeah.
So I tend to really like the fact that we have a Court of Criminal Appeals, because all that bandwidth is directly focused there. But then also there's other certain direct type of appeals that can go there. And again, when we were talking about just like the district court and how a criminal docket can throw off the civil piece, and it's right in that we should prioritize the deprivation of someone's freedom before some of these other matters. That way, we kind of do the same thing at the highest level, that we just have a body that is focused just on the fact that you've been convicted, and now we're dealing with those deprivations right now, and we're focusing solely on that to make sure that we got it right.
And that to me is one of the things that's very impressive to me when you do have the courts of general jurisdiction on the federal level and the state level, is the rules aren't even the same.
Yeah.
Right? You have a whole set of civil rules that you file in civil lawsuits as an attorney, and then you have a whole set of criminal procedure, which there's certainly overlap, but there's entirely separate rule books depending upon what case you have. And I think a lot of people in the public may not know that there is really that much separation in how things have to go.
Yeah.
So types of appeal. We've generally talked about, okay, you're on the Court of Appeals, you see an appeal. I think the way most people think about an appeal, maybe historically, is I go to trial, things didn't go my way at trial, I want to appeal it up from that point.
Yeah.
That's sort of, I will just say, like your classic appeal that you receive. But there's a whole other type, before in pre-production you talked about being extraordinary remedies, extraordinary appeals. Would you mind discussing that a little bit?
Yeah, no. And so you have, appeals in the ordinary course, right? So that means I've got a judgment, I've asked the court, hey, I've got this judgment, or a judgment against me. I think you screwed up. Do you think you screwed up? No, we didn't screw up. Now, the time has passed for the trial court to fix it. Now the next place to go is the Court of Appeals, and that's just the natural course of that. So then you have extraordinary remedies. So your writs of mandamus, right? Your writs of habeas corpus, right? All the body, the person. Yeah, let me out of jail because X, Y, Z was happening. Those extraordinary remedies are informed or kind of created by the equity courts, right? So we, of course, adopted English common law. In some respects, whole cloth. In some respects, we at certain levels just pieces of it. But within the state of Texas and our jurisprudence, we have kind of the normal writs that were there for you in common law, and then the legislature can add specific writs, basically. So, hey, there's certain types of termination of parental rights, other extraordinary things that happen. The legislature say, okay, if this is going on and a court doesn't do something right away, right, you can go right to your Court of Appeals. So the legislature's piled some extra work on us, and we're fine with it because everything they've identified is something that is a panic-inducing situation. I mean, it is hey, stop the presses. This is something that, if the government's going to, and typically it's the government, usually it's the government has somehow, deprived me of something, or this is happening. Court, take a look at this.
And I deal with that a lot in my practice, obviously representing government. You talk about writ. Would you mind explaining to folks a little bit what you mean by a writ? Because I don't think that's a term that people commonly use or commonly understand from a legal standpoint.
I mean, really, it's just a pleading. It's an emergency pleading. It's saying, hey, listen, court, I don't have a record. I may have a very thin record. Here are the facts. I've attached evidence regarding this thing. So, you're going to necessarily be treating it differently than what came from the trial court, because it's fully baked when it arrives to me from the trial court. They did or they didn't do a certain thing. It's all on the record. I take my long, boring walk through the thing and know about it. Here, there's a degree of getting the evidence together and hopefully, if we're talking about a temporary restraining order or an injunction, hopefully the court has put together enough for us to. There may be some instances though where the court has either made a ruling, not ruled, and now we need to direct the court either, hey, go find facts for us, because we're not a fact finder as a court of appeals. That's a very bright line. We're not in the business of taking testimony. We're not in the business of finding facts, but we can direct the trial court, hey, tell us about X, Y, and Z, because if they met these factors, we have something to do here, or we don't have something to do here. So with all these extraordinary remedies, the majority of the talking that we're doing, the most important things that we're saying, are actually to a trial court to get some flesh on what really needs to happen here, get us the facts. If what they're saying matches up with that, then we may in fact be then directing the trial court, do this, do that, and telling them to order someone stop doing what they're doing or someone to turn something over in that regard. So extraordinary in that not, of course, not the ordinary court of process of appeals, but also, I mean, it is use of our power, where we're almost using the district court not as a puppet, but
Giving them guidance on what to do.
Well, actually, I mean, I wasn't even thinking about talking about that when we started the podcast, but I think it's something that's important for people to understand is in a lawsuit, you'll have questions of fact
Yep.
and you'll have questions of law.
Yep.
In very generalized term, when you talk about having a jury, it's the jury's job to determine what the facts are.
Right.
Right. So you go to trial and it's the classic he said, she said. Oh, you did do this. Oh, no, I didn't. The jury gets to sit there and hear the evidence and decide whether or not that person did the thing.
Right.
Most commonly, you talk about criminal cases.
Yep.
Whether they committed the specific acts. The jury has to decide that. Sometimes the parties can allow the judge to.
Just as a brief aside,
Yeah.
juries are best at that.
Right.
Right. We have long found out through psychological studies that however they decided to come to that conclusion, to have a jury do it, 12 people looking at someone and determining whether or not they are truthful is one of the, I mean, sometimes in many instances better than a lie detector. A group of people determining whether someone's being truthful or not is absolutely very effective. So just another reason to have confidence in juries.
I love juries. I love jury trials. I get frustrated because I think the press a lot of times does juries disservice the way they cover things, because they'll cover some sort of like outrageous case. The one for me that always gets me is like the McDonald's hot coffee case. The way that the press and the way like the legend of it usually is discussed is like, oh my gosh, it's so silly. This woman got big bucks because they spilled coffee in her lap. And it's like, no. If you study the facts of that case and how hot that coffee is, and the severe injuries that she suffered because of it, you understand why a jury would do that. And I think there's just way too much of that paints juries in a bad light.
Yeah.
But so you have questions of fact, which largely juries decide. It's possible the parties can agree to have a judge decide those questions of fact. And some of the things you talked about go up on appeal, a judge has to make some factual determinations on. Then you have questions of law. Questions of law, those are reserved for the judge.
Right.
So at the trial court level, okay, jury, thank you for telling me what the facts are. I have to apply those to the law. This is what the law says, and this is what the final judgment of the court is.
Yep.
And when you talk about the Court of Appeals not being in the business of being a fact finder,
Right.
y'all take the facts as the jury set them
In the normal course of
in the
appeals.
normal course of appeals.
And then in the extraordinary, we're asking you find those facts.
Right. Then if you in the extraordinary things, the writs you talked about, you're telling the court, the judge, hey, it's your job to find these facts so that we can apply the law to that.
Right.
Okay.
Right.
That's a really important thing for people to understand, because that's also something that in popular culture is very rarely accurately shown.
Yeah.
You'll see something up on appeal or before the Supreme Court, and somebody will run in through the back door with a piece of paper or something. It's like, yeah, that's not how appeals work.
Yeah. No.
So I want to talk about a couple. You talked about writs. Because there are certain writs that people will commonly hear reported on, I want to kind of have you be able to explain those to the audience a little bit. The first one, I think, is probably the most common one that you hear is a writ of habeas corpus.
Yeah.
Would you mind explaining what that is? Like, what does that mean? It's Latin to me. Like, what
it's the
what is
body,
that?
right? It's the body. The body is being, held against its will. So that is what, the purpose of the writ of habeas corpus is basically, you're holding this person, you're detaining this person. Show me under what power or what authority, that you should be able to hold this person first. Secondly, have you gotten there in the right way? Was there due process in getting to holding the body? And then that's largely what you're fleshing out in those writs. Sometimes there's bond and bail issues that are being sorted out to continue that restraint. But this is all about should this person be set free and how do we do it? And again, facts are there. So you can tell me this is a bad guy. You can do X, Y, and Z here, but did you meet the legal thresholds to inform my decision that this is what we're supposed to be doing?
Right. The other one that I commonly hear discussed is a writ of mandamus.
Yeah.
What is a writ of mandamus?
Judge, you screwed it up so badly that, hey, we are going to be deprived of certain rights. Certain things are going to go off the rails continuously. Court of Appeals, you need to stop what's happening in this process at the trial court level before the case is fully baked, before it's a normal appeal, because by that time we will have lost something so significant. And that's really what mandamus is about. It's basically saying that we cannot wait for the final judgment here. This is whether it is family law, these are all civil matters typically in mandamus. There'll be such a deprivation, there'll be such a diminution of the thing. Reckless spending guy has the account. They're going to keep recklessly spending it. We asked for the injunction. We didn't get it. Hey, you need to take a look at this and stop the bad thing from happening before we've essentially, we'll lose our rights before we had a good clean shot at it.
And another way that mandamus can come up, because I see this sometimes, is it can be used to essentially appeal a decision of a local government, executive. If you're the mayor or something like that, and there's something that you have to do that's just, we call it purely ministerial.
Yeah.
If somebody, if they hand you the application and hand you the check, you must do X, Y, and Z. If those people refuse to act, they can have a writ of mandamus up to the district court level or something along those lines.
I will say this about that. It still is coming under the rubric of, hey, if you don't do this now, there's a time aspect to all this, right? Because the great example is elections deal, right? I'm filing, and this is the filing deadline. Court of Appeals, I need you to decide this now because the deadline closes tomorrow, and by the time I get to a trial, I will already not have been a candidate because they didn't properly accept my application, which everything in law that I have before me and all the facts that I have before me that made it to a court and the court decided not to do anything informs me that I should be on this ballot, right? Well, so
Is that kind of like what you'd see like on election day when they go in and they want to extend election, like voting for another couple hours because of this reason or that reason? It's just very quick and to the point. It seems like the feedback is like super quick.
The first step's in that trial court though, right? Hey, we want an injunction. Hey, we want you to make a ruling. Judge, extend the hours. Judge doesn't do it. They go to us. Or judge does do it. Other party goes to us and say, hey, stop them from doing that. So that's what you're seeing happening. It's always the first stop is at the district court, typically, right, if we're talking about these type of issues. Could be a county court in some issues, but probably rarely.
You mentioned a couple of things that I want to talk about because we'll start moving into some of these recent Supreme Court cases and being able to unpack those. And I think actually discussing them in the election context is good because it's, again, something that people have seen in the recent years that I don't think fully understand. Some of the election challenge type stuff. So you talked about a temporary restraining order. Now, I think a lot of times when people think about a restraining order, they think about it in the criminal sense of like, you're not allowed to come near me. You have to stay so far away. But would you mind explaining in more general terms what a temporary restraining order is and how it's sort of used in federal and state court?
Your temporary restraining order is basically to try to keep things the way they are now before this fight emerged. So, if Bob had the bank account and should have the bank account and he's, spending just fine, we're going to lean toward keeping things the way they were. If Joe takes over the bank account and starts spending away, okay, now we may need to restrain this because we need to see if this is actually Bob's account, right? That's really the heart of it. And basically, you're just trying to keep the status quo and keep the peace until we can take more time and decide, okay, what is really happening here before, letting someone spend out all the money or anything similar, take the child out of the country, things like that.
Right. And not to go into this is what the standard review is, but you've got, some sort of imminent harm, irreparable injury. There's no other way that this person there's no other remedy that this person has to prevent this irreparable injury. So the court has to step in before it's made a final determination on the merits of the case, and just sort of, like you said, keep the peace and keep the status quo.
Right.
So when a court rules on a temporary restraining order, that that is not. I want to try to make sure I'm saying this as generally as I can,
Sure.
to not put you on the spot, as a judge, especially because I might be in your court one day. Very generally speaking, a ruling on a temporary restraining order is not a determination on the final merits of the case.
It's not. It's not.
So you could very well, and I bring this up largely because of some of the Trump issues that have gone up to the court. A court may grant a temporary restraining order up front, but then after full discovery and the full case has gone through, it's fully baked, as you say, they may reach a different conclusion.
Absolutely.
So in federal state court, TRO is sort of the first step. Next, we have a temporary injunction.
Yeah.
What is a temporary injunction?
It's a little more fleshed out, right? So the court's going to take some more time. They're going to, gather a little more evidence, and it's going to have a more durable effect until the proceeding is finished. I mean, temporary restraining orders may have a shorter shelf life. They typically do have, less information in front of them. The temporary injunction can vary from county to county. You can get 20 minutes aside in Collin County to flesh something out. In Dallas County, you can get days to flesh out that injunction. But it's similarly, this is the baby version. This is the bigger version of what is essentially the same legal principle. It's, hey, we're putting things at a status quo that the court sees at this time is going to make sure that no one gets away with taking all the money, taking the kid, doing the thing. We're protecting the status quo until we get to that final, fully informed decision from a trial.
And I'm glad you talked a little bit about the distinction as far as the temporary injunction having more information, because in state court and in federal court, you could prospectively grant a temporary restraining order with only one side presenting information to the court.
Yeah.
Versus a temporary injunction, you're going to have a hearing. Both sides are going to have the ability to present evidence. And then the court is going to enter something that would last until you get to trial, or something to that effect. Is that a fair generalization?
That's a fair generalization, and you also get a crack at saying, like, hey, you get a chance to also weed out some of the thornier jurisdictional issues. Where your temporary restraining order, you can say stop, and then realize actually no, But with a temporary injunction, this is something that is going to be here. It's going to have its home here. This fight's going to have its home here. So while this fight is brewing, I'm going to get a chance to, keep things settled down, keep the peace until we can have a final resolution of it.
And sort of balance rights and stuff along those lines. Generally speaking, I know my clients as municipalities don't necessarily have to do this. Most parties, when it comes to the TRO, the temporary injunction, they have to get a bond to sort of protect the other side. Where basically, hey, if the facts, I don't want to say if the court gets it wrong, but if the court's determination at the temporary injunction is different than what the jury ultimately decides, and the party that has the TRO or the temporary injunction against them is harmed, you've got bonds that can sort of reimburse them for whatever the harm would be. Yeah.
And again, it's but really the whole shebang, right, is just we're keeping the peace, and then if you potentially could have been harmed by how this went out. I'm going to be very careful in how I say this. That bond is there to protect you. You had to expend legal fees to protect the thing that was yours and should have always been yours.
So let's talk about some of the more specific issues that have come through the U.S. Supreme Court. They've received a ton of press, and so there's two cases. There is, and overdoing it. We've got them printed out here. If need be, I don't think that our guest here is going to need that. But you've got the Trump, the AARP, which is an abbreviation of people's names, not the American Association of Retired People, against Trump. And
of course, there are some folks that would like some of those AARP executives sent to Venezuela, for their past Democrat donations. But it's
fair enough. Yeah. Well, and that's what you say. It's this was the deportation to Venezuela. Yeah. We need a temporary. This came out of Dallas, or not came. Did it come out of Dallas?
Northern District.
Northern District.
Yep.
Came out of the Northern District. Yep. This is we need some immediate action. Made it all the way up to the Supreme Court.
Yeah. Quickly.
The other case that we'll talk about is Trump versus Casa. That's the case that had to do with whether one district judge had the ability to do a nationwide shutdown by granting like a nationwide temporary injunction or
Universal
temporary restraining
injunction.
order.
Yep.
So first, and I think just because of the way they went, let's start with the ARP case.
Okay, yeah.
So I think we kind of talked about it a little bit. Would you mind giving our audience a little understanding of what the basic facts are?
Sure. Trump administration has been very active. Unlike some past executives, both Republican and Democrat, they are finding ways to get the job done that they said they were going to get done. Right. So, and I always totally butcher the name of the gang,
Trendo Agua.
Yeah, TRA or
Yeah,
whatever.
TRA.
TRA is, so I'm going to use TRA. They are, and some will argue that the administration shoehorned them into what is a fairly old statute, basically, this Foreign Enemies Act. That if you're a foreign enemy, you're a combatant, you're someone that's trying to take down our government, you're been sent here to do us harm, we can send you back, right? And with very concise authority, we can do that. In reading the statute, there's absolutely, in my mind, I'm not, I don't think I'm really dealing with any of these issues. In my mind, it's a fair reading. It's a fair reading to say that under, people sent here to do us harm. Okay, you've got that part right. The Trump administration basically was giving some of these folks deportation orders. Hey, we're sending you out. You're on your way out here soon. Lawyers for these individuals started taking pictures of the orders that, hey, this is happening as early as tomorrow. And they go to the district court and say, district court, we want a hearing on this. We want our due process. The very highly qualified, and, when we were talking about federal district judges, right?
Yes.
And you were mentioning that they have to know both, criminal procedure and civil procedure. I mean, these are cream of the crop. These guys and gals are really smart.
Your federal district court judges have to get confirmed.
Yeah.
Right. I mean, these are people that will go sit in front of Congress and get grilled, or I would say that they'll get grilled before they're able to be confirmed to sit on the bench. So these are,
Yeah, and they do it all.
Right.
I mean, if they have made good decisions in the past, if they've been on a bench, they've written extensively. I mean, these are the A team in judges. We all look up to them, right? And then, of course, you even look up to the appeals court, the federal, even more.
Yeah.
But these are the best on the bench that you'll see that are hashing over the facts. The particular judge involved here, Hendricks, was that guy, and he had a very short window to make any type of determination about what's happening here, what's happening with the statute, and the lawyers for the gang members basically. The long and short of it is said, hey, you're not making this decision fast enough. They may be deported tomorrow. So, you've got this at 1 o'clock, by 3 o'clock, the state, the federal government has said, hey, they're saying, they want a hearing on this. We're giving you your notice. And the judge is trying to study up on this and wants till midnight basically to do that. The parties in this are the attorneys for gang members are like, nope, we need an answer now. So they go to the Fifth Circuit. Fifth Circuit says, hey, listen, we're not ready for this. District judge has not had a chance to properly rule, gather the facts, do the things that we need so that we can have, we're not fact finders, right? We need him to be able to do his job.
We don't have jurisdiction. We've essentially, and when you hear people talk about jurisdiction, it's like permitted authority.
Right.
The Fifth Circuit says, hey, we don't even have the authority to rule on this.
Right, because it's not fully baked yet at that lower level. So they immediately ask the Supreme Court, get yourself involved here. The Supreme Court takes that opportunity with 7 members in a per curiam, which means that no one justice was assigned the writing, which is telling.
Right.
And then
Why is that telling?
So when you issue something per curiam, usually you're trying to send the message, we don't have any disagreement on this thing. I mean, this is we are very much sending the signal that this is the voice of the court. Now, having two in dissent kind of makes that a little wonky, but so you're sending the signal that these seven here, these principles that are laid forth, there's no creating divisions or cracks. In other decisions, you can have a cobbled together majority where you can have five agreeing with the result, but they have five different reasons on why they got there.
Gotcha.
So when the next case comes up, it can vary widely who you want to be speaking to cobble your majority. If you want to cobble your majority in a case like this, you have seven that are sticking on board with what they said in AARP, and they want to send that signal clearly.
Okay, perfect.
Yeah, because that's another thing when you read opinions from the court. And I'm glad you brought it up because you talked about the dissents. You'll have the opinion of the court. Hopefully,
Yeah.
a majority of the judges that are hearing it, the justices that are hearing it, agree with certain principles. This is the majority opinion.
Yeah.
And then you can have what are called concurring opinions. Obviously not for you, but for audience, where, hey, we agree with the result, but our legal rationales would have been a little bit different. Then you'll have your dissents, which are generally, we disagree with what the court has done. We would have ruled differently. This is how we would have ruled differently. Is that kind of a fair discussion?
Completely fair. And for the folks listening at home, it really does matter when you have those concurrences and it's different reasons why you got there. Because, what is the reason of this? Why are we writing this thing anyway? Well, we're writing it for the future, for the next conflict that comes up. And when the next conflict comes up, if you have a 9-0 decision, you have a pretty good idea of where this thing's going to be, right? If you have a 5-4 and you have people, for different reasons there, if you're on, say, the losing side, the 4 justices side of whatever issue this was, and it's coming on its way up, well, I just got to pick off one.
Right.
And take a look at their rationale, and now it's essentially kind of going the other way. Really important for the rule of law, really important for the parties that are coming up next. So 9-0 decisions are great for settling things. That no one on this court's going a different direction. When it's 1 or 2 in the dissent, it's not. It's just a slightly bit more iffy, but for the most part, where you have to be to get where you're trying to go. 5-4 cases give everyone stress, but that's where the lawyers make their money. So
I guess it's good for yes. And aren't most 9-0?
most are 9-0.
Yeah, I learned that like last year.
Yeah.
I was like, because you only hear about the 5-4. But
Right.
before I asked you that question, we got off track. What happened with this case, though? It went to the Supreme Court, and that's where I interrupted you.
Well, and here's where some people got a little bit concerned. The Supreme Court said, "Time out, stop. We need due process here. We're not deciding on whether or not these folks should be staying in the country. We are not deciding on whether or not the Trump administration shoehorned these folks into an old statute that doesn't fit. All we're saying is we have a due process problem here. They didn't get a fair shot to say to a judge, say to someone, hey, we don't fall under this. Hey, administration, you're moving too quickly." So, if you want to hold up those two opinions, one opinion's much smaller than the other.
Well,
And
it's actually, ironically, so the ARP opinion is the one that we've just been talking about.
Right.
It has to do with the temporary injunction. It's 25 pages with everything.
Right.
Right. This one is smaller because I didn't print the whole thing.
it's 100-something.
It's 119 pages,
Right.
right?
Right.
Including all of the concurrences and the dissents.
Now, do you get excited about reading that?
Absolutely.
I do, yeah.
Absolutely.
Yeah.
My
Absolutely.
God.
So, but I mean, and this is just as kind of a nerdy thing though. And if you're looking at the first 3 pages, right? First 3 pages, I got to tell, as a court, I have to tell you, where am I getting my authority from? It's really light on, this is a court that says, and has been for the most part, very originalist, very textualist.
Right.
And I'm not seeing, we're going through the facts, and okay, so I got a case from '81, I got Bollinger. I'm not seeing, a ton of citations to where, hey, government, you clearly got this wrong. Now, they're not saying government, you clearly got this wrong. So, at least the language there isn't so strong without a lot of the citations, but it's a little light on what is needed here. So they really are potentially making law in this situation, adding some time, not constraints, but
Right.
opening up time response
Yes.
for the district courts, which has been criticized by Justice Ho on the Fifth Circuit. It'll be interesting to see if this is actually where the Supreme Court finally lands, because I think this is more a matter of the brute force and speed of the Trump administration, which
Yeah.
is something that I think
It's great.
the government can be built for. It's
Yeah.
great. The government can be built for it, but it's not yet built for. So they're saying, all right, we're tapping the brakes in this one. I'm very hopeful at some point we get a course correction. Well,
So I'm confused. So this hasn't been flushed out, but they're still deporting people. But was that
Well,
specifically
yeah.
Venezuela and not El Salvador?
so this now, and we can talk.
Yeah, well,
this
did
could
we
lead us.
switch?
No, no,
No,
no,
we
no,
haven't
no.
switched
Okay.
yet. We're
No,
still
no,
talking
no,
about the
but
original.
that's
Okay.
that's an issue that bleeds over
Right.
regarding universal injunction. So you are correct. There are other people getting deported. There are other people getting deported under other statutes, under this statute in different circumstances.
Not the foreign enemies.
Not the foreign enemies, but for the most part, those that are getting deported under the foreign enemies are receiving a little bit, government given notice. We're not just doing it in 24 hours.
Um,
There's a still a short window turnaround, but at least giving everyone time to get to a court.
just to like brainstorm, Foreign Enemies Act is 1798, and they say, oh well, this gang was shoehorned in there, and so I looked up wars around 1800, and like you had the beginning of the Native American Indian Wars when we were expanding west.
Yeah.
So
Barbary Pirates.
Barbary pirates, that's right.
Yeah.
So
But
in
you-
Incursions from Spain, incursions
from Spain
Mexico,
and Mexico.
yeah,
So it's
yeah.
like unless you are a Native American or you're from Tunisia, like my point being is, if you wanted to use this act today, none of these people would be a foreign enemy. So it would kind of make, you know what I'm saying? Do you see where I'm going with that? Like you would have to, almost anybody that you put into a foreign enemies act today would be shoehorned in there, because it's like
Right.
when this was written, these were the foreign enemies that we were worried about.
I mean, I think the statute's written broadly enough. Anyone that's coming here to do us harm, right?
Okay.
I mean, I think it's fair enough to
So
to
like
put it
like an organized gang.
organized gang. It can be an individual. I mean, there's no reason under that. If China sent one guy to blow up a bunch of stuff or to hack or to do whatever, boom, we can use that. You're out, right? We're not at war with them, but this is a malicious act, right?
It's clearly
Yeah, I mean, it's certainly turning up the temperature toward an active war, but and yeah, there are plenty of instances where we're not in a hot war with someone, but there are things that are destructive.
yeah. So okay, cool. So from me being a layman, that's kind of how I thought about this. So
Yeah.
when was this filed again? Like, is there a date on it?
So this was May 2025 is when the Supreme Court
May.
entered their opinion on it.
Okay.
I think. Oh, and actually,
But this was all
probably says-
happening in April.
Yeah, April is when it was filed in the district.
Yeah, I
court.
mean, it's really fast,
That's
right?
super duper fast.
So
on the legal side.
so they have an opinion on it, but it's not done, or it's done.
That's so. The questions you're asking right now are exactly why we're talking about this case.
okay.
Thank you.
So this is, at least from my perspective, my frustration with how the media has reported on it, and a lot of politicians, the parties have talked about it. All this case did, this is the reason we broke down a temporary restraining order, a temporary injunction, then trial. So this was over a temporary restraining order, something that's real quick, right up front. Hey, court, I need immediate action for you to press the pause button.
Yeah.
All the Supreme Court said in this opinion is essentially that the Fifth Circuit had the authority to rule on whether the trial court got it wrong by not granting the TRO in that short period of time. I think the concern to lawyers like myself, and prospectively to judges, is the fact that the window that this judge had to rule on a really complex issue,
Right.
largely of first impression, was half a day. And that's considering that half a day was at night, right? This is filed at like 12 o'clock at night, midnight type of thing. And so usually if you're going to have a court of appeals step in saying that a judge hasn't acted fast enough, there's much more time where the judge is refusing to take an action. Here you're basically like, man, what ability does this judge have to do any legal research, to seek any sort of briefing from the other side or any of that to inform the decision? So for me, that's where this case is really concerning. But it doesn't make any, and actually the Supreme Court specifically said in this opinion, we take no stance on the merits to this case. Like they lay that out expressly. So this case can continue to unfold. Go to the temporary injunction, go to trial, all that sort of stuff. I guess not really necessarily to trial, but have proceedings on whether or not the deportation.
So the definition could, by the end of this, could open up wider to foreign enemies. You could have a larger.
Well, so they're not interpreting foreign enemies. This could have been any statute. They're just saying that, hey, because we have this imminent thing, it can be under any statute.
Okay.
Right? Because we have this imminent harm that can come to this party.
Yeah.
District court, you're going to be required to act within this time. If you don't, now appeals court, you can accept jurisdiction. You can say, constructively that they've constructively denied the injunction, right? Because they didn't hear it in half a day, right? So really, what's happened here is that what the Supreme Court has done, they basically created this due process timeline that is, by all measures, somewhat unreasonable. And in all likelihood, they've forced the hand of a court to see it, accept it, right? So that hurts the Trump administration. So it basically I think I can't see into their heads, but as a strategic matter, it forces the Trump administration to slow down, or else these things in the district courts, as a matter of prophylactic, I'm just going to go ahead and pull the trigger and restrain it until I get a day or two to actually look at the thing. Right. Yeah. So it resets the default. The default is usually not to go ahead and just grant it. The default is usually, I'm going to think about it. I have enough time to think about it.
Yeah. Okay. So a light bulb just went off in my head. I was all wrapped around the foreign enemies thing, which is exactly what the media is doing.
Bingo.
And I'm like in a petri dish here, but because I was all foreign enemies and everyone's like up in arms like I was, but that's what the headline on Breitbart's all about. It's like, oh, this judge is saying that these people aren't foreign enemies and they're so dangerous.
Didn't make that decision at all.
It's a procedural issue with timing.
It's about due process.
Okay.
It's about how we're going to do due process.
And the court, like I said, the Supreme Court expressly stated, they directly wrote in this opinion, we are not taking a position on whether or not the Trump administration has the ability to use the Foreign Enemies Act to deport people. Because that's not the issue that was before the Supreme Court. That's not what they were deciding. All they decided was, the Fifth Circuit should have ruled on whether or not the trial court denied the TRO. Okay. I mean, that's really at the base of it all.
And it's back at the Fifth Court appeals, right?
It came to a new panel, and it'll go back down to the district court. What's really sad about this whiff, though, the media whiff, like totally getting it wrong for the people. It's unfortunate because, it anticipates that, the Foreign Enemies Act is going to be just the only sexy thing. Right?
Yeah.
Major changes in due process, I think if you explain it well, right, and you explain what exactly the court's doing here, because the court is, forcing the hands of these two levels of the judiciary, and also, I mean, probably by extension, because what you can anticipate happening, by extension, forcing the hand of the Trump administration to slow down a bit, right? That's the headline. Right. That's really the headline.
That is
Supreme Court slows down Trump administration.
Ooh.
That's the headline.
And it's crazy because he's put in 3 of them, right? 3 more than any other president. But that's I feel lied to. I feel wildly misled all this time. I'm like, these people are clearly a danger. But it's like that's not what any of this is about.
Yeah, it's not. It's not.
And I will say, as a defense counsel, so this is where I would say, and to your point, the disservice done to the public by how this has been reported on is this. if you're a business owner and somebody wants to go down and get a TRO to stop you from doing something, right? Whatever it is, they're trying to stop you from an eviction. I know that procedurally probably wouldn't work that way, but just as a general understanding.
Yeah.
They filed the TRO at 12:38 at night, right, a.m.,
Okay. Sleeping. Yeah.
and they filed their appeal at 3 o'clock in the afternoon the next day, saying that the trial court hadn't acted quickly enough and that the Fifth Circuit needed to do something.
And that
Right,
was
so
that was who was doing that?
The people that were appealing the deportation.
Okay, gotcha. Yeah.
So just put yourself in as a business owner. Somebody files something in the middle of the night.
Yeah.
Let's say you find out about it at 9 a.m. in the morning, and
They're asking for a status conference at 1:30.
right,
So
And they're
parties got to
wanting-
show up.
right.
Yeah.
So you've got to
Yeah.
go get your lawyer. Your lawyer hopefully doesn't have anything going on that morning.
Not
and
another
can,
courtroom.
Can suit up, be in the court, and be informed enough about this to represent your interests. And while you can have what are called ex parte temporary restraining orders where both parties don't need to be here, here's one where I don't think that would necessarily be appropriate. And what the Supreme Court said is the trial court for saying, hey, let me have a little bit of time to let both sides have a say and for me to think about it. No.
You didn't even have a response from the government yet. I
Right.
mean, you did not have a response from the government yet to this district court judge.
Well, you've been a district court judge. Something gets filed at 12:30 in the morning, right? and then, it's not like every day for you in the morning is just free time. I mean, like if you're sitting there in your experience, I mean, what is that like? What is your morning like? What is your staffing like? How do you respond to something
you got
like that?
you got jail chain. You got the criminal court. But I mean, in all likelihood, if you're running a functional court, you have things to hear in the morning that usually take priority over other things, and then you get to those. So now we're gonna shift everything quickly, and I mean,
No, thank
hope
you.
that it works out.
So is that a tactical thing though, or a strategy thing where it was like, hey, we're probably gonna lose, so let's force the issue now to try to make them hit the button?
I think it was in earnest because they thought and they had seen others be deported in 24 hours
Like
because
roll
that's what
play.
that's what the administration was doing. So I think it was on the part of those attorneys representing the alleged gang members. I think it was in good faith.
Okay. Now, is this issue why we're seeing so many detention camps being built? Like, because there's now a delay on actually getting people out of the country with ICE's arresting them and then detaining them in camps. Is that what has something to do with it, or?
I don't know because I don't know the numbers, but I don't think so because I
Okay.
think this applies, and this is one of the other frustrating things too that doesn't get out there in the press. I mean, this applies to a very small
Amount of
population.
people?
I
They
mean,
would have to be just allegedly a part of that gang.
Yeah, and
Even
Okay.
more narrow than that, right?
Yeah.
Like, even more narrow than
committed
that.
acts we can point to say, hey, you've acted against merit. You could be part of that gang. You came here and you're chilling, right? You're a regular deportation. You came here, you committed crimes. You were intended here to be committing crimes. The Venezuelan government wanted you here, just like some of the Cuban folks were sent over here to cause chaos in Florida. Way back in the 70s, 80s, or
Yeah.
whatever. Like,
Scarface action. Yeah.
yes, there you go. We had to get a good Scarface
Right.
reference.
And he just wanted some disco. That's
Yeah,
it.
that's it. That's
And Michelle Pfeiffer. So that's actually a good transition point to talk about the second case that we're discussing, which is the Trump Casa case.
yeah.
And so this is one that, on the flip side, I'm very enthusiastic about this opinion. Would you mind talking a little bit to our audience about, again, the background on this case?
This this will be important for years to come, and this is one of those cases that as a jurist you're proud of because there were universal injunctions put in place by conservatives, right? Plan B, milprofestone, whatever. There was universal injunction regarding the distribution of that drug as an abortive. And then, of course, on the other side, right, you have Biden's, a whole host of probably best to just talk about these type of things. It's halting the deportations, right?
Right.
So there have been alleged by both conservative-leaning district judges and liberal-leaning district judges the use of the universal injunction, right? And the problem with that is, where does it exist in our common law? Where does it exist in statute? Is it in the Constitution? Well, certainly not in the Constitution, right? So then you go take a peek at the Judiciary Act and what the judiciary can and can't do. Ain't there? I mean, that type
Right.
of, you can't just shut down something for everyone. Rather, you decide cases and controversies that are before your court,
Right.
For your district. Or else it wouldn't make sense for us to have districts. We can just have every judge roving around the country, right? Just, deciding things basically on circuit, right? I mean, and then, there's a model for that. We don't use it
Right.
very explicitly because you determine cases and controversies in the geographic area where you are. Now, granted, the federal government has these important things that do happen. So in this instance, we have the Trump, President Trump decided to issue executive order regarding a birthright citizenship, and a number of parties, go and file in their favored venue. Right, you're gonna pick the judge that's most likely to give you the relief you want. Shut down this executive order.
Right. You're not going to go out to Lubbock.
Nope.
If you're trying to shut down the Trump order, you're not going out to Lubbock or Marshall
Yeah.
and saying, hey, shut this thing down.
But if you wanted to shut down Biden, you would have gone to Lubbock or Marshall. So it's, in some respects, what's good for the goose is good for the gander, but
Right.
it ended up being bad for law entirely because it ain't there,
Right.
right? And as an originalist, as a textualist, it ain't there, so we're not doing it. So this case corrects that in the most spectacular and wonderful way. It says, nope, no more universal injunctions,
Right.
You deal with the case and controversy before you. We have procedures, and Barrett does a great job going over the history of, in responding to the dissent, similar type vehicles that, really are modern class actions,
Right.
right? You can, and that's the thing.
Yes.
You can get a class action,
Right.
right? But you know what? It takes work to get a class action.
Right.
Getting these universal injunctions is a heck of a lot easier.
political stuff, yeah.
Just because it's easy doesn't mean you should do it. And I don't think this is going to usher in an era of the government finally doing the hard things that are right, but at least it's a wonderful example of the Supreme Court saying, nope, you're going to have to do the hard thing here. If you want the entire country to be under that certain ruling, get a class action. We have a way to do this. Do it right.
So if you're wondering class action, you probably hear that used a lot. You've probably seen commercials. You might have got an email claiming that you're in a class. Essentially, when you have a group of people that are similarly harmed by something, the movie Aaron Brockovich is is a good example of this. Maybe you have a neighborhood or a town that's all affected by pollution that's coming from one plant, something along those lines. Instead of everybody having to file their own lawsuit, all of those people can pool in one class and bring one lawsuit against that.
Yeah.
We would call it tortfeasor, but the wrongdoer, whomever the defendant on the other side. And then the court at that point gets to rule on the entire class, which sometimes can extend nationwide to everybody that was similarly affected. I mean, the military gets this sort of stuff all the time, right?
Oh my gosh.
If you were at Camp Lejeune, and
The water stuff, yeah.
The stuff I get in the mail is just, lawyer after lawyer, like, hey, man, like, they hurt you.
Yeah.
I'm like, no, they did. Just go, please go away.
How's your hearing? So that's what a class action is. The problem that this case addressed, the CASA case addressed, is you would have one district court judge not just rule for the parties in front of the judge, but instead say, well, not only am I going to rule in favor of the plaintiff, but I'm just going to go ahead and make my ruling apply to everyone in the entire country. And that's really not how our system was designed. This is why you have, to your point, judicial districts. We have laboratories of democracy in our legislature, and we have laboratories of jurisprudence in our various district courts. Because like you talked about earlier, sometimes you'll have a difference in how the Fifth Circuit
Yep.
in Texas decides something and how the Ninth Circuit in California
Yep.
does. And so what this case says is like, hey, you get to rule on what's in front of you, on the parties that are in front of you. You don't get to make this apply to everybody in the country.
Yeah.
But, and this is a thing that I really wanted to harp on with this, because I saw liberal journalists cover this very dishonestly as well.
No.
Oh, this is just stripping people of their rights, and the court and the government's going to run amok. And it's like, no. You still have a right to go to, if you think that the Trump administration is doing something to you that is unconstitutional, you still have the exact same right to go take it to a judge and get your own ruling on
Yeah.
it. It doesn't take those rights away from anybody.
Yeah. Yeah. No, and it's important to kind of, the historical context is touched upon in a couple different ways, and I think it's helpful to go back to the common law. I mean, literally, the concepts around class actions started in the common law. We're a bunch of, normal folks. There's a lord. He's doing this. We're asking a court of equity, stop this guy from doing this. We are the one individual that steps up really is sticking their neck out, right? Right. So if a bunch of us that are similarly situated come forward, well, wait a second. I'm usually just determining cases, one guy versus one guy, Well, okay, now we're building this concept that, okay, similarly situated individuals, it can be 1v, 20 peasants.
Right.
And, that's where this concept first comes in play. And there's a lot of positive things regarding the justice of that, right? I'm not sticking my head out alone in that historical situation. Also, representation is cheaper for these individuals that are, fighting the larger power. So analogously, right? And when we talk about our class actions, we're usually talking about a class action lawsuit. When we think about it in common parlance, big company, right? Poor people that are affected by this, not necessarily monetarily poor, the unfortunates that are dealt, that got the Monsanto poison, whatever, right? Whatever it is. And, they have a cause of action. And it's easier for them to pull together, one lawyer, and they all get relief because they're all similarly situated. We're deciding one issue or a couple issues, so judicial economy's there. I'm not using a bunch of time up on all these trials. This, right, is about a bunch of injunctions. So remember, we were talking about injunctions not being the fully baked trial, right? So they're trying to enjoin, before we've even gotten to the merits, the government from enforcing the law in a bunch of places.
Yeah.
Now, the counter argument, and it's somewhat, it's not nonsensical, is that, if a person in Texas is being beat down by this new statute improperly against their rights, well, then all the other individuals clearly are as well throughout the country. Why should they have to file their individual lawsuits? Right. Well, they may have to start initially doing that, but then there can be the class action, right? And it takes some hoops, right? There's some procedure to it, but it's not a forever thing. So, while the individuals have to stand up and say, stop, governments, stop in Massachusetts, stop in New Jersey, stop in Texas, that class is built. And then there can be the class then enjoining and then getting it right.
Wraps them all together.
It may take a little bit more time, but that more thoughtfully will be able to be presented to the court to truly, having a nationwide injunction based on one case and scenario. That could be dicey, right? Because then you do have the potential for forum shopping, all this. If you have a bunch of places, right, then you really know that there is this common thread. We all have this right that has been potentially impinged upon. And then we're going to go forward in a more orderly manner and really decide all of these people's real individual right versus what the government is trying to do here, rather than what could be a really imperfect injunction until we get the right answer, which could be 4 or 5 years down the road.
And you also have procedural vehicles like consolidation,
Yeah.
right? You can have, if you have a bunch of different lawsuits that are on the same set of facts, the same application, the same statute, the courts already have the ability to consolidate those cases together. The thing that infuriates me about the argument of like, oh, well, what if somebody from this state has it applied differently than this other state? It's like, we have always had that.
Yeah.
Right. There are constitutional causes of action that are recognized in other parts of the country that you can't bring in the Fifth Circuit.
Yeah.
Right. There's application to federal civil rights statutes, like employment law statutes, where the way a court would rule in a federal court would rule in Oregon is different than how the court in Texas would rule. And the Supreme Court has yet seen the need to take that up. That's the sort of circuit split you talked about earlier, where maybe the Supreme Court will rule. But I'm just saying, for as long as we've had courts in different parts of the country and federal statutes, we've seen different courts apply them differently. That's why I talk about courts having that sort of laboratory of jurisprudence, because reasonable minds can differ on how to interpret a statute. It is, in my opinion, best for our overall jurisprudence of getting it right to allow different legal minds and different communities around the country to consider those questions on their own and make their determination. And if ultimately the Supreme Court wants to exercise its authority to synthesize that, they can.
Yeah.
I guess you could apply this to anything that goes to a court. It's 2025. Why are we just now getting to one judge cannot slow down, dictate, or make a speed bump for the entire country?
Because it happened slowly. It was really boiling the frog, because this was not, the universal injunction was not something in the 20s, right? 1920 wasn't there, right? Lochner era, right? You start getting a little further, then you start getting into the 60s, and the courts start, and that's why, I talk about, or kind of mentioned before, when things got wild, the Warren Court. And so the Lochner era, so you have post and during FDR, right? And to the 60s and to the 70s, right? You have this era where era and error, where a lot of law was made that doesn't make a lot of sense. Some things, and some procedural things in particular, seem to have emerged from panic rather than, okay, let's take our time with this. We have vehicles to handle this. The universal injunction is very much a sign of panic, right? Quick, do something about it now.
Yeah.
And
a lot of panic these days.
yeah. I mean, we as courts are in the job of not panicking, making good decisions based on what's in front of us, knowing that it's going to affect decisions down the road. So that means, it's going to take some time. You got to gather all the things. You got to make sure that you're, getting all the credible pieces of evidence. You're hearing all the arguments. You're fleshing it out. Measure twice, cut once, right?
That is something that is massively, I will say in my practice, and I didn't benefit from the pre-email era of practicing law, but I would have professors in law school would talk about how it used to be so great because you had to send them a letter.
Yep.
You had to schedule an appointment. Things did have to be filed at the courthouse. You'd have to set the hearing.
Yeah.
It would take time for legal decisions to be made.
Yeah.
So you could make better informed legal decisions. Whereas now, you get an email, it's like the AARP case, right? The expectation is that judge at 12:34 in the morning is going to wake up as soon as they get a ping that something's filed, and the answer is automatically going to be in their head one way or the other. They don't need to research it. They don't need to consider anything. I mean, it's just the way that I think a lot of people treat the legal community like it's Chat GPT. It just doesn't work that way.
I'm assuming when they say filed, it's literally a website and you just upload your case and that's being filed. It's not like someone's going down to the courthouse at 2:30 in the morning.
E-filed,
Yeah.
yeah.
Okay.
Yeah.
Yeah.
You still can go down to the courthouse during operating hours,
Yep.
but yeah, there's an e-filing system.
Yep.
As far as nationwide injunctions, I believe FDR had a few, maybe not, but I have a screenshot here starting in 1981. So Reagan had 30, George H.W. Bush had 20, Bill Clinton had 42, George W. Bush had 76, Barack Obama had 80, Trump had 160 in his first term. Biden had 133, and of course we're 6 months in, and here has 11, but that's only as of March 23rd.
I don't think that number's going to get much higher for this.
Yeah, it's not going to get much higher. But
That would be
what?
awesome.
That trend, and if you could show that to the
Yeah, I'm gonna put it up on the screen for sure.
It's very, very telling,
It's
right?
growing.
Yeah, it grew, but now that problem is stopped. And basically, the judiciary saw their mistake. That, the Supreme Court saw the mistake that by letting this go unchecked, it became what's good for the goose is good for the gander. So, liberal-minded folks, conservative-minded folks are going to start doing this, and I don't necessarily, is it an attack on the executive? and it was certainly an overreach. I mean, you're not in the business of determining, finality regarding what should happen in the interim before the final judgment comes at a trial. That's really, really presumptuous and lacking humility from these district judges.
They don't have a lot
That
of
is-
humility.
yeah.
They're very sure of themselves. I mean, I don't know if you can comment on this. I mean, why do you think that Republicans, I mean, just based off the numbers, Republican presidents have gotten so many more nationwide injunctions on things they were trying to do compared to Democratic presidents?
I think for all the reasons that we usually suspect. I mean, the left has been very successful in achieving their aims through the courts, right? Some will call it lawfare,
Yeah.
other, there's, so, I mean, if something's not broke, right? So they have, ideologically aligned hordes of attorneys. They have money there to spend on these cases, so that they're going to be in that business, right? They're going to be in that, when all the world's, or when you're a hammer, all the world's a nail. So that,
Yeah.
the lawfare thing has been effective. They're going to do that. Even when, I mean, and if you, peek at some of those situations, I
Yeah.
mean, you're going to look at George W. Bush at a time when, he had a Democratic Congress. Well, wouldn't it have made sense to push through legislation? Well, of course, Bush is going to veto it, and so we should just go right to the courts. Well, should you try? Should you try with the constitutionally appropriate route by filing legislation, arguing on the House? I mean, when we were dealing before the Civil War, we talked about some of the weightiest issues, and we put those bills in front of presidents, and they had to veto them.
Yeah.
And we did it because that was part of the national conversation. That was the right way to do things.
Yeah.
So unfortunately, and that's not to say that the right is now untainted by that. We did it to Biden. We absolutely did it to Biden. We took that same weapon,
Yeah.
and unfortunately, that weapon, should we be gentlemanly and not use all the weapons at our disposal? Probably not. But I mean, should we get back to
Well-
a place where we do things like that, where we actually file legislation to fix a problem? That'd be better.
It would be better. I mean, me and Chris kind of talk about this where it's like Democrats will create a weapon or a system or something, and it's like Republicans are, hey, man, we shouldn't do that. Like, we're kind of, we want to conserve, right? We want to, well, that's not how we do things here, like you said, but they're like, that's not the mentality of the political party. And so they create this weapon, and then, next time around, like, okay, fine, we'll use that as well. And that would be awesome if we could get away with this. I guess as you guys are saying, we probably won't see any nationwide injunctions. I'm curious to see what the next weapon will be. But
It'll be filing I mean, in all likelihood, if they still want to go down this route, if anyone wants to go down this route, they'll move toward class actions, and that's fine. It's more thoughtful. It's slowly done. It's put together right. You're going to get that geographic diversity. You're going to get are these really similarly situated cases? You get a better decision, right?
I agree. Yeah, the class action will be the way to go. I will also say one of the reasons that Republicans maybe didn't have this in the past is the Federalist Society wasn't around soon enough.
Yeah.
I mean, one of the big things that people understand is that, I think everybody understands that liberalism largely dominates in academia.
Yeah.
You can't be a lawyer without spending a good amount of your life in academia.
Yeah.
Right? So there is you will get lots of liberal push becoming a lawyer and going through that process, and liberal professors. I mean,
Yeah.
I don't think that you would think of SMU as being a liberal bastion until you go to the law school and start talking to some of the professors. And there are some very liberal professors at SMU teaching in the law school, at least historically there have been when I was there. But the Federalist Society really changed a lot of that, because for the first time, at least that I'm aware of, there was an organization of conservative-minded lawyers. And so you could get that training, you could get that experience. You
Yeah.
also had somebody that was there to help lobby for certain conservative judges to get in the positions they needed to be and serve on the court and organize some of that. I think a lot of the uptick in conservative, I guess, effective conservative use of the courts,
Yeah.
I think you could track back to the Federalist Society being pretty effective.
Well, and I'd also say that we all owe, everyone in the nation that considers themselves conservative owes the Federalist Society a debt of gratitude regarding winning the fight for originalism and textualism, because there was a point where Bill Clinton says the era of big government's over. Well, Obama went and flipped that on its head real quick.
Yeah.
That lasted all of 10 years or whatever. But when you look at the success of first Ed Meese and those really working with the Federalist Society, and then Scalia's rise in the court to prominence, you have Justice Kagan, you have those appointed by Democrats saying, we're all textualists now. We are all originalists now. We won that fight. Textualism and originalism, kind of go hand in hand. That is so important that fight was won by us. That is such a huge intellectual battle that we won. And I hope more folks recognize that and pay homage to the forebearers that made it happen, because it's a huge win for the rule of law.
Can you give me like a 2-minute breakdown of what you're talking about? Because
Sure.
I don't know what you're talking about
Sure.
as far as like textualism and
Originalism?
Yeah.
Okay, so remember when I talked about Lochner, Warren Court, right? Penumbral rights. You had years and years where they were just making it up. I mean, really making it up.
Real quick, those are the names of the chief justices of the Supreme Court during that time.
Uh-huh.
That's generally how you refer to an era of the Supreme Court.
Yeah,
Okay.
Lochner cases.
Lochner,
yeah,
yeah.
that's just so that was just the reaction. Basically, conservative justices basically gave in to FDR, so they didn't get
Right.
court packed, right? And then
yeah.
all the way through the Warren Court, I mean, you had ridiculous things like talking about penumbral rights. I mean, really made up rights did not exist in the text of the Constitution, was not considered, when the Constitution and the Bill of Rights were put together. I mean, really got off track. And then the reset came, slowly with intellectuals that built up the Federalist Society and espoused textualism. So textualism is basically saying that I'm not going to look at the legislative history. These courts back in the 50s, 60s, and 60s especially would look at legislative history. They would take anything to interpret the statute in a way they saw fit.
Okay.
Scalia effectively made the argument that the thing that was passed, right, the legislature passed this thing, not speeches on the floor. They passed the words on this page that were then passed to the executive that signed the words on this page, and that is the law. The text of that law is what textualism is, right? Same thing with the Constitution. The founders, right, meant what they said when they said, these are your, this is what Fifth Amendment, this is what your right to trial is. This is what, your right to bear arms, right? What was the generally accepted meaning of those words on the page? Not what was said, in the conventions, not what was said. We're not talking about abstract letters that came from, the letter to the Danbury Baptist. When we're talking about your rights, we are talking about the words on the page of the Constitution and the words on the page of the statute. And that's what we're interpreting. The originalism piece of it, of course, is tying in that original meaning and intent of those words. So during that era, there is a little bit of historical analysis to say, okay, what is the meaning of bearing arms?
Right.
And some people might want to try playing games. Well, it's not a rocket launcher.
Right.
It's a thing to kill both animals and people, right?
Sure.
That's what it is to bear arms, right? So using that. So textualism and originalism have won out. And it is so critical in the rule of law. So when people argue in front of the Supreme Court, they don't go and pull reams of data, reams of reports on the legislative history. They used to do that in the 60s. They used to say there was a speech on the floor that said X, Y, and Z, and that's what they meant to be in there. Nope.
Gotcha.
The words on the page and what was signed by the executive. And that's what that law means.
Or they would decide, this goes back to the originalism piece, that, okay, well, we're just going to recontextualize what these words mean in modern parlance. Like, oh, this is what we mean when we say X, Y, Z now. So, like the example of the right to bear arms. Well, it wasn't really meant to be a weapon of war. This is just going to be something people can hunt with. And it's like, well, no, like it might have only been, a musket, but that was the same musket that,
Right.
the regular military would have been using, right? The Continental Army would have been using that musket. That's the sort of stuff that before originalism won out, it was like, well, we're just going to redefine these words to what we mean now.
Yeah.
And not really give any sort of credence for how they actually were intended to be used.
And to add that,
What the words actually were defined as at the time.
and to add the textualism part to that, to that Second Amendment. I mean, for the militia, right? So we are not, we are grammatically interpreting this like this is to kill people.
Yeah.
If you have the right to bear arms,
Yeah.
so that we, at some point, of course you can hunt and do stuff like that, but you can bear arms so you can form a militia. Arms for a militia are to kill people, not to kill bears. Not to, you know what I mean? So you can have weapons that kill people and are good at killing people because for the well-ordered militia, right? So textualism, originalism, boom.
Perfect. Thank you. Yeah, I kind of had this like over, when I hear, briefly, I don't sit up Saturday night like y'all and listen to old recordings of judges and whatnot, but when I hear liberal
New
judges,
recordings. You can listen to the Fifth Court of Appeals anytime you want to, Kyle.
everything's
I'll invite you
recorded.
over to the house.
Or
and we
don't
can
even
hear
bother
oral
watching this
arguments.
YouTube channel. Just go directly to their website and watch that. But like you get the sense of like liberal judges when they start pulling things from everywhere.
Yeah.
And it seems kind of like the word very liberal. I mean, they're casting a massive net to try to make their case. And it, as far as for me watching, it just seems very kind of dishonest. I mean, it's honest and true to themselves because that's who they are, and they want to make their case and they want to win their fight. But as far as where the law ends up and where it goes, it's like, well, at this case, I mean, you're kind of running a dangerous game because we go back to the weapon thing. Like, if the right really wanted to do that, I think they probably would be better at it and can come up with some pretty dangerous situations for people. Like, well, I mean, someone said this on the House floor, and we had this, and we had that, and then come up with some very, like, well, it would make a lot of liberal people cry, so.
Well, and that's a good point that, there are instances where you could do that, but it's a race to the bottom.
Right.
The use of universal injunctions was a race to the bottom. It was bad for both sides. It was bad for our country. Thank God, the Supreme Court had the strength to put an end to that problem, right? And that was, wise judgment on their part. And hopefully, we're going to continue to see things like that from the Supreme Court. That let's do the hard thing. Mm-hmm. For example, right, Chevron deference and where that all went.
Yeah.
So Chevron deference,
that's really going to roll back the EPA, from what I understand.
Bingo, right? So basically, Congress gets to be super lazy. I tell the administration, the executive agencies, hey, make the rules.
Yeah.
I'm going to make this very broad law that I'm never going to be held accountable for back home because you guys are going to do all the bad stuff. You're going to impose the fines, and you're going to determine what the fines are, and you're going to determine who gets fined because you're going to determine that this level of water poisoning is this, and but I never did that. Oh, the EPA, they went wild, right?
Right.
So I get to totally be taken out from this thing and never really have a vote on anything besides appropriating, which is why I hate Congress. But when the Supreme Court that they've gone down that road by reversing Chevron deference and saying, you know what, it's going to be up to a court, and you know what, who should be doing it? It should be Congress making those rules.
Yeah.
We don't have the experts, then get them.
Right.
Like,
you guys have a printing press. I mean, what is the issue here?
Yeah.
They could hire anybody. And that's like that is something that it seems, another win that has popped up recently, because you get into a situation where, people talk about, not liking DC and I guess the deep state, but it really is unelected people making laws in which you have to live by.
Yeah.
And it's like, well, hold on one second. And there's really not any recourse, especially if you're like a small business. So what are you going to do? Take on the federal government? No, you're gonna lose your business going broke trying to fight them.
Yeah.
And they kind of know that.
Yeah.
That's why the IRS likes to fine me every year like $800 because they know I'm not gonna be able to fight it. So, side note.
Well, and actually, both of you kind of were touching on something that I want to talk about a little bit before we close.
Yeah.
You're talking about liberal judges versus conservative judges. Well, we're in a state where our judges are elected, right? Federal judges are all appointed.
Yeah.
For commonly in general senses in Texas, our judges are elected. Would you mind talking a little bit about, what are the differences that people should be thinking about? Why does it matter if there's a Republican judge versus a Democrat judge? But then also, like, how do you deal with partisanship within the judiciary? Because ideally, we should all just be trying to find out what the law is.
Yeah. I have been, a great example, right? In the AARP case, we had Ramirez on that panel, who's a Biden appointee, who, basically was saying like, hey, we don't have jurisdiction because this thing isn't ready yet, right? So there are plenty of instances where you have, in the federal judiciary or here in Texas, someone who's Democrat or Democrat aligned making the good originalist textualist decision. You may differ with them greatly politically, but there are times they're members of our own party, Republicans, that can be activist, right? It comes a lot regarding disposition. I think it's easier to find Republicans that will not be activists because, for the most part, our party rewards that, right? I mean, we reward doing the hard thing. Sometimes it takes a lot of explanation to say, hey, listen, I know you hate the result in this case, but this is what the law was. And God willing, we'll always be that party that does that. So I think that's really where the big difference lies. It is intellectually the right thing to do the hard thing, follow the law, even when the result is seemingly somewhat perverse. But you got to follow the law. And having a base and a grassroots that is willing to reward those individuals that will do that hard thing and is willing to listen to them as they articulate why that thing happened. When you have, good originalists, textualists, and just, patient and humble, right? And when you have those people, then I think most Republicans will say that's the judge that I want. There are plenty of instances, particularly with the far left, they want someone to fight. A fighting judge is a really, really bad thing, right?
Right.
I mean, you're supposed to, take it in, decide what is right on what's before you, knowing that it will be used later, that, it has a place in precedence. Not so much at the trial court level, but on courts of appeals and, of course, on the Supreme Court or state Supreme Court, absolutely, right? So, fighting for the thing necessarily involves, some emotional effort and, what feels right at the time and doesn't necessarily properly take into consideration the long-term effects. So I hope that remains, the great distinction that, Republicans, we reward that thoughtful patience and humility, subordinates to the law, following the rule of law, while, Democrats at their worst extremes, really advocate the opposite, right? Changing things in the fastest way possible because the legislature won't do it and the executive's bad. So give us what we want now. Kind of brute force judges, which is not at all what any judiciary ever should be anywhere. I mean, no one wants a brute force judge in Germany, even though they have different ways of doing things, just as we don't, certainly don't want it here in the United States.
Yeah, I'm always taken back to the Reagan quote, which is the best way to kill a bad law is to enforce it. It's just like, if there's a bad law in the books and it's enforced by the judges, people will know that that's a bad law and the legislator will get kicked in the pants to go fix it.
Yeah.
As opposed to having a bunch of fiefdoms of judges out there who are like, well, I'm going to create an exception to this law because I don't like it. So, well, I thank you so much for joining us tonight and sharing so much of your wisdom with our audience. I think that the judicial branch may often be one of the less understood and poorly reported on branches of our government. So it's very, very helpful for you to be able to take the time to inform citizens, hey, this is what it is. This is what you can expect. Appreciate you taking the time tonight. Kyle, did you have any closing thoughts, any of Kyle's current events or anything like that?
Man, I learned a lot here. The wool was definitely pulled over my eyes on the Foreign Enemies Act because that's and I read all the major conservative headlines and man they will take you down a rabbit hole. I don't have any. I think we should just keep it strictly on this. It was a really awesome episode and everyone's going to learn a lot. So.
I hope so, and I hope they keep learning because listen, if you're here in Texas, you're voting on your judiciary, and you got 3 branches of government. And you're going to bang up against the executive and what they're doing sometimes, right? The legislature is going to, you read about in the paper, they're going to ban this or they're going to do that. But you are going to go to court at some time, right?
Yeah.
That's going to happen. Or a loved one's going to go to court. And, what do you want for them? You want the best result.
Sure.
But, beyond that, you want the process to be fair and thoughtful and, you don't don't want to get run over, right? So I'm hopeful that folks will continue to learn about the judiciary, tell their friends, about it around election time, about what it means to have conservative judges and what it means to, have the not conservative judges. Because I mean, if you do want those right results regarding the thing you're most likely to bang up against, you better have guys like me around.
Absolutely.
Well, I appreciate that, and I appreciate our audience for watching this newest episode. Like, share, subscribe on YouTube, share us on social media. I mean, this is a law school quality, quick education. We obviously may should apply for CLE credit for this, but this is very helpful information. Share it wide. Let your friends, let your family know. Like, this isn't a matter of you trying to persuade them politically. This is just you trying to help them understand the form of government we have, the justice system that we have, so they can have appropriate expectations, so they can understand what their rights are, and so they can better understand when the courts actually take action. As always, if you have any questions, leave them in the comments, and we look forward to seeing you the next time.